and welcome to yet another episode of the news series. My name is Pooja Dwivedi. Today we are going to discuss the conviction of Rahul Gandhi in the defamation case by using incorrectly the name Modi in a speech. We are also going to talk about his disqualification as a member of the parliament. We will know all about it from the perspective of your GS Mains Paper 2nd examination. We are also going to discuss a very important case, the Lily Thomas case. So all these are important from the perspective of your preliminary as well as mains examination. These are the many topics that we are going to discuss step by step. First of all, let us look at the news. Congress leader Rahul Gandhi on March 23rd has been held guilty and sentenced to 2-year jail in a 2019 defamation case over his remarks over the name about the surname Modi by a court in Gujarat's Surat. Now, the judge has convicted Rahul Gandhi in the Indian under the sections of IPC 499 and 500. By pronouncing the judgment, he also gave bail and suspended the sentence for 30 days for Rahul Gandhi to allow him in order to appeal to a higher court, appeal in a higher court. Section 500 of the IPC prescribes for defamation a simple imprisonment for up to 2 years or a fine can be done or both, and under this only he has been convicted. Now, why does Rahul Gandhi face disqualification? He has been disqualified until and unless a stay will be put by a higher court. First is there are 3 modes of disqualification. We have to go through them one by one. First is through the Articles 102 clause 1 and 191 clause 1 for disqualification of a member of the parliament and a member of the legislative assembly respectively. The grounds here include holding an office of profit, being of unsound mind or insolvent, or not having valid citizenship. Very, very important from the perspective of your preliminary examination. Please do copy it down or take a screenshot. The second prescription of disqualification is in the 10th schedule, the anti-defection law. It provides for the disqualification of the members of the parliament on grounds of defection when they change one party or the other, and for that only that destabilized the parliament for many years. So in 1985 this was done. The third prescription is under the Representation of People's Act 1951. Here there are provisions for disqualification for conviction in criminal cases. Section 9 of the RPA deals with disqualification for dismissal for corruption or disloyalty and for entering into government contracts while being a lawmaker. Section 10 deals with disqualification for failure to lodge an account of election expenses. Other than that, Section 11 deals with disqualification for corrupt practices. Section 8 of the RPA deals with disqualification for conviction of offences, and this provision is aimed at preventing criminalization of politics and keeping tainted lawmakers from contesting elections. Now, what does the RPA say other than this? See, first disqualification is triggered for conviction under certain offences which are listed under Section 8 clause 1 of the RPA, such as promoting enmity between two groups, bribery, and undue influence or personation at an election. Under this only Azam Khan was also disqualified. Section 8 clause 2 also lists offences that deal with hoarding or profiteering, adulteration of food or drugs, and for conviction and sentences of at least 6 months for an offence under any provisions of the Dowry Prohibition Act of 1961. Section 8 clause 3 states that a person convicted of any offence and is sentenced for imprisonment of not less than 2 years shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years. That means if this is upheld by other courts as well, Rahul Gandhi will not be able to contest elections for the next upcoming 6 years. Moving ahead. Now, how does the disqualification operate? It can be reversed. In the current case, it can be reversed if a higher court grants a stay on the conviction or decides the appeal in favor of the convicted lawmaker. In a 2018 decision in the Lok Prahari versus Union of India, the Apex Court clarified that the disqualification will not operate from the date of the stay of conviction by the appellate court. Remember this. Other than that, significantly, the stay cannot merely be a suspension of the sentence under section 389 of the CRPC but a stay of conviction. And under section 389 of the CRPC, an appellate court can suspend the sentence of a convict while appeal is pending. So this is very simple language, and it is written so that it's totally fact loaded. So it is written for you to ensure that you get a screenshot or note it down properly so that confusion does not exist. This is akin to releasing an appellant on bail, and this means that Rahul Gandhi's first appeal would be before the Surat Sessions Court and then before the Gujarat High Court, and then so on. Section 8 clause 4 stated that the disqualification will take effect only after 3 months have elapsed from the date of conviction. Okay, but this has been changed. We will talk about that as well. Within that period, lawmakers could file an appeal against the sentence before the High Court. However, in the landmark ruling of 2013 in the Lilly Thomas versus Union of India case, the Supreme Court has struck down Section 8 clause 4 of the RPA as being unconstitutional. Now, if we talk about the Lilly Thomas case, in 2005, a PIL was filed in front of the Apex Court by a Kerala-based lawyer, Lilly Thomas, and NGO Lok Prahari through its General Secretary. They challenged Section 8 Clause 4 of the RPA as ultra-vires of the Constitution. It protected convicted legislators from disqualification on account of their appeals that are pending before the High Courts. So this plea sought to clean Indian politics of criminal elements by barring the convicted politicians from contesting elections, and while they do so, holding the official seat. Article 102 and Clause 1 and Article 191 Clause 1 were the main articles this PIL attracted attention to. So Article 102 Clause 1 lays down the disqualification for members to either house of the Parliament, Lok Sabha, Rajya Sabha. Article 191 Clause 1 lays down disqualification for the membership to the Legislative Assembly or Legislative Council of the state. And the plea argued that these provisions empower the centre and more disqualification. Okay, moving ahead. Now, before the judgment, convicted MPs could easily file an appeal while holding their official seats. This was ultra vires. Now, on July 10, 2013, a bench of Justice A.K. Patnaik and S.J. Mukhopadhyay said that Parliament had no power to enact subsection 4 of the section 8 of the Act, and according subsection 4 of the section 8 of the Act is ultra vires to the Constitution. The court also stated that if any sitting member of the Parliament or state legislature is convicted of any offences under subsection 1, 2, 3 of section 8 of the RPA, then by the virtue of such conviction and or sentence, they will be disqualified. Okay, moving on. Now, a convicted parliamentarian or legislator's membership will no longer be protected by section 8 subclause 4 as was previously the case. So this was all about the conviction and disqualification of Rahul Gandhi. For more such news, stay tuned, stay updated.